If your employer says they investigated your harassment complaint and found no wrongdoing, well, I have news that will change your life. Last week, the California Court of Appeal just handed sexual harassment victims the most powerful legal weapon we've had in decades. And most attorneys don't even know it exists yet. I'm Brian Hannemann. I've been fighting for harassment victims in California courts for 33 years. And I'm about to show you how one court decision, Paknad versus Superior Court, handed down this week, just blew up every employer's favorite hiding place. Here's a problem every victim faces. In 90% of harassment cases, the victim, you file a complaint, you go to HR, you tell your manager, all right, you're supposed to, that's good. But then the employer brings in an outside firm, a lawyer, to quote, investigate. You say, well, that's great, they're going to look into this. Months later, you finally get told the investigation has found insufficient evidence or no policy violation or unsubstantiated. Case closed. When you ask to see the investigation report, they say, nope, attorney-client privilege. We can't show you. When you sue, they claim the investigation proved they did nothing wrong. See, we did an investigation. Nothing happened. But you still can't see what the investigation actually found. How is that fair? Right. It's the perfect legal shell game. They use the investigation to defend themselves while keeping you from seeing if it was even real. Until now. Paknad changes everything. On April 17, 2026, the California Court of Appeal published Paknad versus Superior Court, and it just destroyed the employer privilege game forever. Here's what the court held. Please listen carefully because this could save your case. When your employer claims their investigation was thorough and adequate, they waive attorney-client privilege. You can now demand to see the actual investigation report, the witness interviews, credibility assessment, everything. The employer cannot pick and choose what to show you. The court said factual findings, credibility assessments, and investigative scope all become discoverable. No more hiding the smoking gun evidence. This applies to every employer defense based on investigation adequacy. Whether it's Fortune 500 companies, school districts, hospitals, or government agencies. If they claim they investigated properly, turn it over. The files are now fair game. What does this mean for you in your case? I've won millions of dollars in jury verdicts against employers who've claimed their supposed investigations that were legitimate and unbiased somehow exonerated them. And I can tell you, most of these investigations were jokes. In my Vandervoort case against Fontana Unified School District, $6.5 million. The district claimed they investigated thoroughly. Well, when we finally got the files, we found they never interviewed key witnesses, ignored obvious evidence, poo-pooed certain things, swept it under the rug. In Yang versus Global Wind, multiple million-dollar verdict, same story. The company's thorough investigation turned out to be a cover-up. Now, thanks to Paknad, you don't have to wait until trial to expose the truth. You can demand those investigation files up front. Here's what we'll likely find in those files. Witnesses who were never contacted. Evidence that was ignored or minimized or misstated or completely false. Predetermined conclusions before any investigation even started, and then instructions to protect the company, not find the truth. Please, to every victim who's watching this, I know why you're watching this. You reported harassment. You're fearful. Something happened. You want it fixed. Your employer claimed, oh, well, we investigated. And then they told you nothing happened. And now you feel crazy, alone, and powerless. Okay, you're not crazy. You are not alone. And you are definitely not powerless anymore. The Paknad decision means we can tear apart their fake investigation. We can expose how they protected your harasser instead of protecting you like the law requires. We can prove they prioritize corporate reputation over your safety. But here's what you need to understand. Most employment attorneys don't yet know about Paknad. They're still fighting the old way, letting employers hide behind privilege while victims get destroyed. I've been studying this decision since the day it was published. I understand exactly how to weaponize it for harassment victims. And I know how to turn your employer's fake investigation into the evidence that wins your case. If you're in California and your employer claims they investigated your harassment complaint, you have a window of opportunity that's never existed before. But please, you need to act fast. Evidence disappears, witnesses forget. And employers are already learning to change their investigation language to avoid Paknad. Here's what you need to do right now. Call my office. Tell me, call me, talk to me. Tell me you saw this Paknad video. The consultation is free. I'll set it up. You can do it in person, over the phone, or Zoom. We'll review your situation. Bring any documents you have about the investigation, emails, reports, witness statements, anything. We'll evaluate whether Paknad applies to your case. If it does, we'll demand those investigation files immediately. And if we find what I think we'll find, evidence of a sham investigation designed to protect your harasser, we'll get going. We'll make them pay for it. 909-244-3850. Brian Hannemann at the Hannemann Law Firm. Mention the Paknad consultation. 33 years I've been fighting for harassment victims in California. We know WellPoint and we know Paknad. Paknad's the new landscape. We know how to use it, and we know how to win. For 33 years, I've watched employers hide behind fake investigations while victims suffered in silence. The Paknad decision just ended that game forever. Your employer's investigation files are no longer their secret weapon, ours. Subscribe to this channel for more breaking legal analysis. Hit the notification bell because this landscape is changing fast. And remember, you don't have to face this alone anymore. The law just shifted in your favor. Let's use it.